Hello, everyone. I am going to be doing something today that I am not sure how it'll go. What I'm going to do is I'm going to read word for word the body and text of a piece of legislation that came out in Florida this week. I think it was this last week. Um, I've got it on my screen over here. And the bill is 1557, and it is from the Florida House of Representatives. And it's the Parental Rights in Education Amendment. Amendment 2, it looks like a Bill 1001.42. I have no idea what that is. I'm assuming it is basically modifying an already established code um, when it comes to education. Um, as I'm sure people know, this bill has been called the Don't Say K Act. Sorry, let me try that again. The Don't Say Gay Act. And this term was applied to the bill by those who oppose it. On the other side of the coin are the people who support it, who call it the anti grooming bill. From what I have seen of the bill, and I've read through it, but this will be the first time I actually fully read through it, so I might be learning something. Um, what I've seen of the bill, it's neither. It is not anti grooming, and it is not a Don't Say Gay Act. These are terms that are used by both sides to demonify. Um, I forget what it's not demonify. There's a term for it. Demonize the bill and those who wrote it. This has actually led to me losing a friend who I knew for 30 years who was gay, who was falling for the media narrative of Don't Say Gay. When I have read it, I just simply have not seen it. So I'm going to go ahead and put my eyes on, and I'm going to read what is on my screen here. So there'll be moments where I'll be looking at the screen as I'm reading. And this may be dry as hell. So dry, in fact, I've got something to drink so my throat doesn't dry out. Because the last time I talked for a long period of time, my throat dried out. Okay, so without much more ado, here we go. An act relating to parental rights in education amending S 100-42 FS semicolon requiring district school boards to adopt procedures that comport with certain provisions of law for the notifying of students' parents of specified information, semicolon, requiring such procedures to reinforce the fundamental right of parents to make decisions regarding the upbringing and control of their children in a specified manner, prohibiting the procedures from prohibiting a parent from accessing certain records, providing construction, prohibiting a school district from adopting procedures or student support forms that prohibit school district personnel from notifying a parent about specified information or that encourage or have the effect of encouraging a student to withhold from a parent such information, prohibiting school district personnel from discouraging or prohibiting parental notification and involvement in critical decisions affecting a student's mental, emotional, or physical well-being, providing construction, prohibiting classroom discussion about sexual orientation or gender identity in certain grade levels or in a specified manner, requiring certain training developed or provided by a school district to adhere to standards established by the Department of Education, requiring school districts to notify parents of healthcare services and provide parents the opportunity to consent or decline such services, providing that a specified parental consent does not waive a certain parental rights, requiring school districts to provide parents with certain questionnaires or health screening forms and obtain parental permission before administering such questionnaires and forms, requiring school districts to adopt certain procedures for resolving specified parental concern, requiring resolution within a specified time frame, requiring the Commissioner of Education to appoint a special magistrate for unsolved concerns, providing a requirement for the special magistrate, requiring the State Board of Education to approve or reject the special magistrate's recommendation within specified time frame, requiring school districts to bear the cost of the special magistrate, requiring the State Board of Education to adopt rules, providing a requirement for such rules, authorizing a parent to bring an action against a school district to obtain a declaratory judgment that a school district procedure or practice violates certain provisions of law, providing for the additional award injunctive relief, damages, and reasonable attorney fees and court costs to certain parents, requiring school districts to adopt policies to notify parents of certain rights, providing construction, requiring the department to review and update as necessary the specified materials by a certain date, providing an effective date. Okay, I think that was the preamble of this thing. It is really thick with what I call legalese because I'm a pilot and I deal with FARs, or Federal Aviation Regulations, which are so steeped in legalese it makes your head spin. And this definitely was an example of legalese, especially like the bits of providing construction. I have no idea what that means. I just read word for word the preamble. All right, so now we actually get into the meat of the thing. So before that, okay. So let's see. Next slide. Be it enacted by the legislature of the state of Florida, Section 1, paragraph C is added to subsection 8 of section 100.42 Florida statutes to read 1001.42 Powers and duties of district school board. The district school board acting as a board shall exercise all powers and perform all duties listed below, 8. Student welfare. I think this is paragraph C1. In accordance with the rights of parents enumerated in SS 1002.20 and 1014.04, adopt procedures for notifying a student's parents if there is a change in the student's services or monitoring related to the student's mental, emotional, or physical health or well-being, and the school's ability to provide a safe and supportive learning environment for the student. The procedures must reinforce the fundamental right of parents to make decisions regarding the upbringing and control of their children by requiring school districts to encourage a student to discuss issues relating to his or her well-being with his or her parent, or to facilitate discussion of the issue with the parent. The procedures may not prohibit parents from accessing any of their students' education and health records created, maintained, or used by the school district as required by 1002.22, subparagraph 2. 2. A school district may not adopt procedures or student support forms that prohibit school district personnel from notifying a parent about his or her student's mental, emotional, or physical health or well-being, or a change in related services or monitoring of that encourage or have the effect of encouraging a student to withhold from a parent such information. School district personnel may not discourage or prohibit parental notification of and involvement in critical decisions affecting the student's mental, emotional, or physical health or well-being. This subparagraph does not prohibit a school district from adopting procedures that permit school personnel to withhold such information from a parent if a reasonably prudent person would believe that this discourse could result in abuse, abandonment, or neglect, as those terms are defined in S39.01. All right, I'm going to write that down. I'm going to write down that second paragraph because I want to discuss that one, because there is a massive thing in there about a choice being given to the school personnel. All right, so now we're on to 3. Classroom instruction by school personnel or third parties on sexual orientation or gender identity may not occur in kindergarten through grade 3 or in a manner that is not age appropriate or developmentally appropriate for students in accordance with state standards. I'm going to write that down because that is a major contention point that I've been hearing. And I think I can understand what they're trying to say there. All right. 4. Student support services, training developed or provided by a school district to its school district personnel must adhere to student services guidelines, standards, and frameworks established by the Department of Education. 5. At the beginning of a school year, each school district shall notify parents of each healthcare services offered at their student's school and the option to withhold consent or decline any specific service. Parental consent is a healthcare service to a healthcare service does not waive the parent's right to access his or her student's education or health records, or to be notified about a change in his or her student's services or monitoring as provided by this paragraph. 6. Before administering a student well-being questionnaire or health screening form to a student in kindergarten through grade 3, the school district must provide the questionnaire or health screening form to the parent and obtain the permission of the parent. That's another one I'm going to write down because there's some things in that one. Okay. 7. Each school district shall adopt procedures for a parent to notify the principal or his or her designee regarding the concerns under this paragraph at his or her student's school and the process for resolving those concerns within 7 calendar days after notification of the parent. Subsection A. At a minimum, the procedures must require that within 30 days after notification of the parent that the concern remains unresolved, the school district must either resolve the concern or provide a statement of the reason for not resolving the concern. That's legalese. If a concern is not resolved by the school district, a permit may request a parent request Commissioner of Education to appoint a special magistrate who is a member of the Florida Bar in good standing and who has at least 5 years of experience in administrative law. The special magistrate shall determine facts related to the dispute over the school district procedure or practice, consider information provided by the school district, and render a recommended decision for resolution to the State Board of Education within 30 days after receipt of the request by the parent. The State Board of Education must approve or reject the recommended decision at its next regularly scheduled meeting that is more than 7 calendar days and no more than 30 days after the date of the recommended decision is transmitted. The cost of the special magistrate shall be borne by the school district. The State Board of Education shall adopt rules, including forms necessary to implement this subparagraph. 2. Bring an action against the school district to obtain a declaratory judgment that the school district procedure or practice violates the paragraph, and seek injunctive relief. A court may award damages and shall award reasonable attorney fees and court costs to a parent who receives declaratory or injunctive relief. C. Each school district shall adopt policies to notify parents of the procedures required under this subparagraph. D. Nothing contained in the subparagraph shall be construed to abridge or alter rights or of actions or remedies in equity already existing under the common law or general law. Section 2. By June 30th, 2023, the Department of Education shall review and update as necessary school counseling frameworks and standards, educator practices and professional conduct, principles and any other student services personnel guidelines, standards, or frameworks in accordance with the requirement of this Act. Section 3. This Act shall take effect July 1st, 2022. End. That's 7 whopping pages of legalese and of this whole thing. Now, you will note throughout that entire thing, the word gay did not appear, the word LGBT, the term LGBT did not appear, the word trans did not appear. The only reference to those would be the gender piece. Okay, so I'm going to go to section 2. A school district may not adopt procedures or student support forms that prohibit school district personnel from notifying a parent about his or her student's mental, emotional, or physical health or well-being or a change in related services. I'm going to stop on that one. I'm going to make my way down to, I'm going to provide the link for this PDF because there are, minutes, how on legal sheets they have the minutes on the side. So I'm going to go to minute, there. It starts at minute 91. This subparagraph does not prohibit a school district from adopting procedures that permit school personnel to withhold such information from a parent if a reasonably prudent person would believe that discourse or disclosure would result in abuse, abandonment, or neglect, as those terms are defined in section 39. Okay. This one paragraph is sort of the fail-safe of this thing. A lot of people seem to think that this thing will make it that kids will be outed, like a gay kid will be outed to his or her really bad parents. There are. Let's face it, there really are bad parents, okay? And sometimes it can be really seen that these parents may not be all that nice towards finding out their child is gay, okay? So a reasonably prudent person, I'm not sure what that means. I think maybe someone who has all their screws tightened, they don't have a screw loose, are looking at how, say, do you guys remember what was his name? He was a terrible person. He did Phelps. Yeah, I think his name was Phelps. But he basically had those protests at like funerals of soldiers and all that sort of stuff going on about gay people and how gay people were going to hell and how gay people being accepted in our... Fred Phelps. That was it. Fred Phelps. Okay, so you have someone who is associated with Fred Phelps, right? And they have all the earmarks. They hate gay people. They're out and open about it. They just hate gay people, right? Their kid is gay. Or their kid has gay tendencies. Their kid could be like how I was when I was growing up, okay? This kid would not, through this one paragraph, this kid would not be outed to those violent parents, okay? And I'm doing a more extreme example, but I'm sure there are other avenues, all right? So that section there pretty much eliminates this fear of kids being outed to rotten, horrible parents. And yes, they exist, okay? I've seen it on YouTube. I've seen fathers saying really nasty things about femboys and saying, if my boy ever came home dressed like that, I'd beat the shit out of him. Okay? This stuff happens. All right, so now on to 3. What was 3? Classroom instruction by school personnel or third parties on sexual orientation or gender identity may not occur in kindergarten through grade 3. Fair enough. This is the fuzzy part. Or in a manner that is not age appropriate or developmentally appropriate for students in accordance with state standards. So now you got to refer to the state standards. But this is the one that is causing the trouble. This is the wording that is causing the issues. This is the wording that actually led to my friend unfriending me because I was saying, dude, it doesn't say what you're saying. Okay? It's the part about in a manner that is not age appropriate. What the hell does that mean? Well, you got to go by with state standards. They did, instead of explaining it here, they're having you refer to another thing, and I'm not looking for that other thing, because no one's going to look at that other thing who is going by the media narrative that this says is a don't say gay bill. From what I see of this bill prohibits discussion, classroom discussion about sexual orientation and gender identity. The gender identity I have issues with. I don't think kids in kindergarten through grade 3 need to be hearing about sex at all. But then other people have been bringing up a very cogent point, and that is about should Sleeping Beauty be brought up in classes? Because the prince kisses the girl, doesn't she? And there are some people who do consider kissing to be a sexual act. That's because we live in a weird society. But there we are. All right, paragraph 6. Before administering a student well-being questionnaire. Okay, so I guess these are like questionnaires to to be distributed to kids. And basically what they're saying is before those questionnaires are put out, parents have to approve them. I don't see why this needs to exist, but I'm not a parent. So, I mean, yeah, I'm not understanding why that's there. But I can see what they're trying to say. They're saying before the questionnaire can be put out, a sample of it needs to go out to the parents. And it needs to be, and the one that is approved by the parents is the one that has to be handed out to the kids. It cannot be modified. That's fair enough. That's kind of understandable. Now, but so I think it's really disingenuous what the people who don't like this law are doing by calling it the Don't Say Gay bill, because it doesn't say that at all. There's nothing in here that says that at all. It's a prohibition of classroom discussion for grades 1 from kindergarten to 3 about sexual orientation, and that includes straight. That includes heterosexual. In fact, you probably can't say the word heterosexual. You probably can't say straight. Probably say a boy and a girl. I don't know. Now, something this does not discourage or prohibit, from what I see, is one-on-one or small group discussions concerning these things. So it's like, that's actually more than I had when I was growing up. When I was growing up in kindergarten, I was told that boys didn't wear skirts and boys didn't wear dresses. Girls could do whatever they wanted, by the way. I have a feeling that maybe that kind of talk won't be permitted either. If a boy wants to wear a skirt, he can wear a skirt. You just don't say, oh, he must be a girl. That's fine. That's fine. He could just be a boy exploring skirts. And there's nothing wrong with that. Although we treat it like it's a horrible thing. So anyways, that was the bill in its entirety. It is 7 pages. I will link it. I will put the link in my poster. And I hope I was able to at least get some clarity on it. It kind of pisses me off that my friend decided to unfriend me because I was trying to say, no, the media is spinning things out of control on this one. And they are. As far as I can see. If you think there's something else going on, please, in the discussion below, nicely state so. And if you can find the standards that they're talking about, bring that up too. I'd shared a link. Let's get a discussion going on this. Let's not allow this to keep spinning out of control and friendships being destroyed. So that is it for this, and I hope I wasn't too dry, and it was a lot of legalese, and that is a problem with a lot of this sort of stuff, is the legalese is just so overwhelming at times. All right, that is it. Bye-bye.